Okay, so do you actually own your digital assets? I mean, really think about it for a second. We deal with this stuff every single day. Maybe you're holding some crypto, you've got a killer domain name, or you just manage gigabytes of super important files. You have the passwords, right? You control the accounts, so naturally, you own them. Well, legally speaking, the answer is kind of terrifying. It's basically a massive "we are not sure." And honestly, it's a tension that is literally keeping the brightest legal minds up at night right now.
Welcome to this explainer. Today, we're going to untangle the whole fascinating legal ontology of digital property. We are diving into the UK Law Commission's Call for Evidence, which is basically this foundational document trying to figure out how on earth the law should handle the things we own in cyberspace.
Here's our roadmap for today. We're going to hit the digital ownership dilemma, look at the common law binary, explore a third category of property, figure out how to define a digital asset, and wrap up with the practical and legal implications. Let's get right into it.
Starting with Section 1, the digital ownership dilemma. Let's look at the immediate headache market participants face when they just try to define ownership in a digital world.
Look, we interact with incredibly valuable digital items all the time now. From Bitcoin to carbon credits to domain names and even just the emails sitting on a server. But right now, it is entirely unclear how traditional property law actually applies to any of it. It leaves everybody, from massive institutional investors down to you and me, in complete legal limbo. Because without a crystal clear definition of property, you can't easily use these assets as collateral, and protecting them from theft becomes a total legal nightmare.
There's this really fascinating concept that legal scholars brought up to the Law Commission called the locked room analogy. You might think, hey, I have my password, I hold the private crypto keys, so I own the asset. But legally, scholars argue that it's just a technical means of control. It's literally like having a key to a locked room. If the law doesn't recognize the digital item inside that room as actual property, well, your possession of the key means absolutely nothing in a courtroom. Sure, you can lock other people out, but you don't legally own the rights to the asset against the rest of the world. Crazy, right?
To understand why this is such a tough nut to crack, we gotta move to Section 2, the common law binary, and look back at the really strict historical foundation of English personal property law.
So, here is the crux of the issue. For centuries, the common law has operated on this incredibly strict binary. Every single thing you own as personal property is forced into one of two buckets. First, you have a thing in possession. That means a tangible, physical object you can actually hold in your hand, like cash or a gold bar. Or second, it's a thing in action, which is an intangible legal right you can enforce in court. Think of a debt someone owes you, or shares in a company. Physical things or legal rights to sue. That is literally it, the whole shebang.
And this wasn't just some casual guideline. It was famously cemented into law by Lord Justice Fry way back in the 1885 case Colonial Bank v. Winnie. He flat out said, the law knows no tertium quid between the two, meaning there's no third thing. Just pause and think about that. The bedrock of our property law was locked in place 3 years after the first Electric Lighting Act in the UK. Electricity was in its absolute infancy, and yet this is the exact same framework we are trying to use to judge cryptocurrencies today. It's wild.
Which brings us to the breaking point. Digital assets completely shatter this system. And that brings us to Section 3, a third category of property.
Because here's the thing, assets like Bitcoin aren't physical, so they definitely aren't things in possession, but they also don't represent a legal claim against anybody, so they aren't things in action either. They just exist on a decentralized ledger. So to fix this giant crypto wrench in the legal system, there's a massive push to create exactly what Lord Justice Fry said didn't exist, a tertium quid, a third thing. The overwhelming consensus from legal experts is that we urgently need to formally recognize a brand new third category of personal property made specifically for the digital age.
And look, this isn't just some fringe academic theory. Top legal minds, we're talking heavy hitters like Professor Louise Gullifer from Cambridge and Professor David Fox from Edinburgh, are directly urging the Law Commission to make this happen. They make the case that it's just analytically tidier to recognize a third category, instead of awkwardly trying to shove digital assets into old, ill-fitting 19th century molds.
And you see this exact sentiment echoed by the Financial Markets Law Committee, or FMLC. Now, when you realize that the FMLC represents institutions that deal in literally trillions of pounds of securities, you know their words carry some serious weight. They've stated flat out that a third category is absolutely essential. The market desperately needs legal certainty so they can confidently grant security interests, handle complex insolvencies, and really just keep the enormous global trade of digital assets moving smoothly.
But establishing a whole new category?
That is a huge paradigm shift. So let's hit Section 4, defining a digital asset. Where exactly do we draw the line?
Okay, so this is where things get really tricky. The Cloud Legal project at Queen Mary University brings up a huge risk here. If the Law Commission defines these new digital assets using super strict criteria, like, say, requiring them to be rivalrous and divestible, meaning only one person can use it at a time and you can transfer it completely away, well, that perfectly describes a Bitcoin, right? But they might accidentally leave out everyday digital items. If the definition is too narrow, our personal digital files, our databases, our emails, they might end up with zero property protection at all.
Plus, leading global law firms like Linklaters have jumped into the debate, pointing out that trying to shoehorn these brand new assets into traditional concepts of exclusive possession is just a recipe for disaster. Instead of getting totally bogged down in strict categories that just mimic physical control, they're suggesting we need a more functional approach. Basically, we need rules that focus on the intended commercial outcomes, how these assets actually behave and function in the real world.
So, why does any of this matter outside of a law library? Let's get into Section 5, practical and legal implications.
Defining digital property isn't just an academic exercise. It's absolutely required so that market participants can safely do business. Without a third category, it is incredibly risky to take digital assets as collateral for a loan. It makes it legally murky to establish bailment, when you trust a custodian to hold onto your assets, and recovering stolen assets, good luck. But most importantly, clear property rights are an absolute must if we want to safely operate highly automated, programmable financial markets.
A perfect example of where tech meets law is the ERC 3643 standard on Ethereum. You might know it as TREX, or Token for Regulated Exchanges. This is an institutional-grade smart contract system built specifically for issuing permissioned security tokens. See, unlike Bitcoin, where basically anyone can hold it, securities are heavily regulated. You cannot just send a tokenized company's share to some random anonymous wallet. The law demands strict KYC and compliance checks.
And because those regulated securities need that strict compliance, the TREX standard essentially automates all those legal rules right into sequential on-chain steps. It's actually brilliant. First, the smart contract checks the sender's balance. Then, it checks an on-chain identity and KYC registry to make sure the receiver is legally allowed to hold that specific security. And finally, it executes or blocks the transfer completely based on those embedded legal parameters.
Systems like TREX show exactly why the law has to adapt. You've got this incredible code trying to automate compliance, but that code needs a rock-solid legal foundation to stand on. As the FMLC pointed out, establishing a third category of property is really the only way to resolve this core tension. Right now, we're basically trying to regulate highly automated cryptographic financial tools using rules written for horse-drawn carriages and paper stock certificates. It just doesn't work.
Which brings us to the end of this explainer, and I want to leave you with a bit of a provocative thought to chew on. As our digital economy keeps expanding to include everything from our money to our art to real estate, are we actually legally equipped to protect our modern assets? Or are we going to stay trapped in an 1885 framework forever? The steps the UK Law Commission takes next aren't just going to define British law, they are very likely going to set the precedent for the entire global digital economy. Just something to think about the next time you log in to check your digital wallet. Thanks for joining me.